The Money Show. Personal finance.
Well, Warren Ingram out today. Sharon Hamman is joining us instead, a senior legal advisor at Momentum. But let me first just set the scene. So imagine that you draw up a will, you get it from a certain place, and off you go. And unfortunately, you pass away. And then this is what happens at that moment when everyone's around waiting for the will to be read.
All my assets, both liquid and otherwise, I leave in their entirety to Marta Cabrera. My entire ownership of Blood Like Wine Publishing, I leave in its entirety to Marta Cabrera. The copyright of its catalog, likewise, I leave in its entirety to Marta Cabrera.
No. That's not.
No.
That can't be.
No.
Can I see that, please, Alan?
That's right.
Please.
This can't be legal.
It's right.
Can you imagine? If you're wondering, it's from the movie Knives Out. But can you imagine if that's what happens with your will? Well, Sharon Hamman is one of those people who makes sure that it doesn't. Sharon, good evening, and thanks so much for joining us on Personal Finance tonight.
Good evening, Stephen. It's good to be here.
Okay, so we're talking about why you need to actually make sure your will is sorted out. And I know that you can get wills online, you can buy them, you can fill them in, and it's kind of done. But there are many issues that happen when you do this. And one of the things is a will which is valid but is not executable. What does that mean? Why would a will not be executable?
Yeah, I think a lot of people think they've drafted a will, or even if they do a homemade will and they've signed it and they've got the witnesses to co-sign with them, that everything is sorted. But the difference between having a valid will, which means that you fulfill the requirements of the Wills Act, is quite different to having an executable will, which is where the executor can actually give effect to your wishes. So similarly to your example, you are dishing out your assets. You're saying my house goes to this child, my investment goes to that child, the vehicles go here, and everybody's happy because they're getting something. For the executor to then come in and say, the executor is the person that's got the job to actually deal with this estate. And he says, well, it's all great and lovely, but you first of all have to pay me to do my job. Secondly, receiver of revenue is standing in line because there's something like estate duty that might be payable, or there's expenses because we have to pay the transfer costs to transfer the property to you. There's debts that must be settled. So all of a sudden, the thing is, we've got all these assets, we've each got a claim to it, but we can't have it because we're going to have to sell it to actually pay all these expenses. Where if you made sufficient provision by doing a proper estate plan and you could determine, okay, I've got a lot of clients are asset rich, but they don't have a lot of cash. They can say, let's make provision for it, either by way of life insurance or by way of earmarking a specific asset that can be sold to generate this cash to then give effect to all the other wishes that I've basically put in my will, so that the executor can then sort the whole estate out without having to dispose of those assets.
Okay, I mean, there's another issue, which is what's called, and I always find the pronunciation of this tricky, it's the intestate succession. So intestate, if I remember, is what happens if someone dies without a will.
Yes. So if you die without a will or a valid will, then you will fall under the Intestate Succession Act. So it doesn't mean that the government takes all your money, because some people believe that. That does not happen. But the Intestate Succession Act is very clear in how assets are distributed. So the big risk is that what you might have intended to happen will not happen because of the Intestate Succession Act. So if you've got a spouse and children, the Act determines that a spouse will get a child share plus one and the kids will get the rest, where most often the spouse should be or is the only heir because they obviously often have to still look after the children. So to leave it to the Interstate Succession Act is really risky because it will not necessarily pan out the way you want it to.
What does a child share plus one mean?
So if you've got 3 children, they will divide the estate between that, and the spouse gets basically one share plus another one. And there's a minimum which she will get, which is 250,000 or the child share plus one, whichever is the greater.
Okay, I mean, it's an interesting way to work out a formula. So I mean, that would be spelt out quite clearly. That's what happens if you die without a will. Does it also take longer? I mean, one of the problems that people have is someone passes away, the bank is formally told, they immediately freeze all the accounts. I can understand why they do that. And then it can take a long time to actually get the money out. If you die interstate without a will, does it take longer?
It tends to, because all of a sudden somebody has to take control of the process, and they either have to go to the master's office to get themselves appointed as an executor, because somebody must still administer the estate, whether it's in accordance with the will or whether it's in accordance with the Interstate Succession Act. Someone must still take control of that. So you will have to go to the master's office and say that this estate has to be lodged, and then they will determine who the executor is. If you don't want to nominate yourself, because often family members would want to do that, the master can insist that you appoint an agent to support you, because they tend to favor people that have a legal background or an accounting or some sort of experience in this field to assist the family to sort out the administration. So even just that process to find the right person or to get yourself appointed will take a while. And then obviously the heirs might not be happy, so there might be some disputes that go on. And also obviously keeping in mind, even though you've got the Interstate Succession Act, the creditors and the receiver of revenue generally stands in line first.
Sure. We're taking your calls tonight, 011 883 0702 021 446 0567, and voice notes on 072 702 1702. We're speaking to Sharon Hamman, a senior legal advisor at Momentum, about your will, about why you need to make sure that everything is done properly. I suppose the reason, Sharon, and tell me if I get this right, the law does that. And the problem is that sometimes people become estranged from a spouse, but they're still legally a spouse. Sometimes even you become estranged from your children. And in fact, the people you love most, or the people you want to get something, could be someone completely different. Could be your next door neighbor or the person who's helped you through something. And yet that's not taken into consideration unless you have a proper will.
Indeed. If you are married, in terms of the Marriage Act, or even in terms of a religious tenet or a customary marriage, or in a permanent long-term relationship, and the person can prove it, then they will be seen as a spouse. So even for the Interstate Succession Act, they can have a claim. So if you do not want to include somebody in your distribution of your assets upon your death, then a will is definitely the place to start. Just keeping in mind, if you are legally married and you do have a spouse, and even some of your other forms of marriages, even if you disown your spouse, there is something like a Maintenance of Surviving Spouses Act that you might still have to contend with, because inherently the rule is, if you wanted to marry somebody and you didn't go through the trouble of getting divorced or having a formal separation, you might still be held liable to maintain them in some form or fashion. But there's also, once again, a process that you have to go through. It's not just a given.
Sure. All right. When you pass away, and I mean, somehow, obviously, SARS was going to get a look in on this conversation, there is still taxes, the two certainties in life.
Yes, indeed, there is. Obviously, when you die, you as a natural person taxpayer, your tax year really ends the day of death. So you first of all have the tax liability for the year whilst you were still alive until the day that you die. And then on that same day, a new taxpayer is born, which is referred to as your deceased estate, and any income and interests or anything that's earned by that estate whilst it's being wound up will still be subject to normal income tax or capital gains tax. In addition to just the normal taxes, when you die, for capital gains tax purposes, it is seen as if you have disposed of all your assets. So to make sense of it, you can really see that the living person is disposing of their assets in favor of their estate. So there's a deemed disposal for capital gains tax purposes. So upon death, capital gains tax is automatically triggered. There are certain exemptions or exclusions that apply. Most common is that if all the assets go to a spouse, you don't pay that capital gains tax. or your primary residence exclusion will still continue to apply. So all the normal exclusions that you have during your lifetime will apply. The only other difference is that during your lifetime, if you dispose of an asset, you get up to 50,000 as an exclusion for the gains that you've made for capital gains tax, where on death, it is 300,000. I actually think it's changed in the budget recently. Just going to double check that.
There was a change in the budget. Yes, I think
Yes.
there was. I can't remember exactly what happened. Okay, so I mean, the worst thing would be if you get some sort of tax and then as a result, some of the assets have to come out of the estate and be sold or something like that. I mean, it's an awful story, but it must happen from time to time.
Yeah, some assets have to be sold to pay taxes. Obviously, also if assets are disposed of, or if assets go to anybody else but the spouse, you have a liability of potential estate duty. So each person has up to 3.5 million rand that can pass to anybody else, as I say, other than the spouse, that will pass estate duty free. But over and above that, you will incur estate duty up to 25% for any estate value up to 30 million, and then 25% for the assets over and above that. So once again, if the receiver of revenue is due to be paid and there's no liquid funds to do that, then assets are going to have to be sold to make that payment. Or alternatively, heirs can be asked that if they want to pay that because they might want to preserve the assets. So if there's family property and a farm may be involved, they might not want to sell that asset. So then they will have to come up with the cash themselves to settle the estate debt, because tax is really just another estate debt.
Sure. Okay. So you have children, you have minor children, or you're guardians of them. You need to make sure they're looked after. How do you do that properly?
Well, first of all, having a will is the first step, because in your will, you will be able to nominate a guardian for your children. Keeping in mind that if you are divorced, the natural guardian, so the father or the mother that appears on the birth certificate, will be the natural guardian. So you can't really replace them unless you've gone through a legal process to do that. But let's say you're the only parent, or you and your spouse are deceased together, you can appoint a legal guardian. Once again, it's not a given. The person that you have appointed as a guardian in your will still has to accept that nomination. So it's very important to have your will in place, but also to have those discussions with the relevant people before you actually finalize those decisions, to make sure that they are prepared for what's going to happen, so that you don't nominate a guardian and eventually they do not want to accept because they might not have the financial means themselves to look after your 3 children for the rest of their lives. And then secondly, to once again do the proper estate planning. So consulting with the financial advisor to do the necessary calculations to see what the cost will be to bring up those children and educate them, and then making the necessary provisions. And very often families use testamentary trusts that are once again set up in your will to look after, administer, and control the money for the benefit of those children until they reach either majority, which is 18, or you can even say that it's until they're 21 or 25, depending on each person's preference.
We're speaking to Sharon Hamman, the Senior Legal Advisor at Momentum, about a will, about estate planning. Your questions for her, 011 883 0702 021 446 0567, and voice notes on 072 702 1702.
The Money Show. Personal finance.
Sharon, it's a popular subject, I must tell you. Patience is on the line from Soweto. Patience, hi. You're on the line to Sharon, and you have a question.
Yes, please. Thank you. So my issue is my father passed 6 years ago and had a will. But what happened is the attorney who was handling the matter was struck off the roll without our knowledge. And as soon as we found out, we actually reported the matter to the LPC. And up to now, maybe 2-3 years ago, up to now, the matter hasn't been resolved and the estate has not been fully. Part of the estate have been transferred to my mother like a house. But now the issue is we are stuck because the LPC is taking long, and part of the monies in my father's estate were actually chowed by the lawyer who was dealing with the matter at that time. So what would be the next best step to take?
Sharon, I mean, it's a complex case and there'll be many facts to it, but it's very hard to know what to do in a situation like that when basically a lawyer, I presume, has been struck off for a reason.
Yes. Never told us.
No, sure. Yeah. Sharon, I mean, as I say, it's a difficult one, but I would imagine that this is a complex case.
Yes, it's unfortunate, Patience. Hello, I'm sorry to hear about this. Unfortunately, quite often the choice of executor does make a difference, and you can only make that decision in your will initially, either appointing somebody that you trust and they can perhaps outsource to an executor eventually. Or if you've appointed somebody, like in this case, unfortunately, the process is going to have to take its course. So I always try to say we have to make decisions while we still can to appoint reputable. I prefer, obviously, I work for a company that's got a estates executive department and we administer estates, but I'm not saying necessarily momentum per se, but bigger companies tend to have longevity because one person's dishonesty or one person's resignation or even death will not impact anybody's estates because the reality is there's somebody that will step in the next day. Where if you are with an attorney and they are struck off the roll, like in your case, or in some instances, perhaps even dies themselves, then everything is frozen in time and a new executor must be appointed. The fact that it hasn't been resolved in this time frame, to me, also says that there's possibly some factors involved that will need a little bit more scrutiny. So I would say try to get into contact with one of the larger executor companies to see if they can perhaps assist you with sorting this out. You can contact me if you want to, and we can see if we can assist you.
Patience, I'm sorry to hear that, and good luck to you and your family in this. Alan in Joburg, hi.
Yes, good evening, sir.
Go for it. You have a question for Sharon, yeah.
Yes, I have. So it's a bit of a complicated one as well. My wife's parents are both deceased, and her father died in an insolvent estate. Two separate people doing the estates. Eventually, one of the banks was supposed to be the executor, and they eventually pulled the plug and said they don't want to be involved anymore because obviously it's an insolvent estate. So my wife has got involved and she's now become the executor. The problem now is that both parents have died. The house that her father owned, her brother stayed in, but the house can't be transferred because the mother's not around anymore and there's nobody that can pay the debts because the brother racked up all kinds of debts. And as a result, the house has now been taken over by vagrants. How do we actually solve this problem? Because, it's only the house before they can wind up her father's estate, and they can't wind up the mother's estate until the father's is wound up because this house is supposed to go to the mother.
Sure. Alan, thank you. I mean, Sharon, this kind of thing does happen from time to time.
I know, and unfortunately it happens quite often where things like this happen. I've had examples where families do not report deaths and they do not report estates, and people live in houses, and eventually 1 or 2 generations later they want to sell the house and then realize it's still really in the name of somebody that's been deceased for quite a number of years or even decades. So it is problematic. In this case, once again, administration of an estate is a legislative process. There's a whole process that has to go through. So yes, the one estate will have to be finalized before the next one can go through the process. And they should really have sold the property as part of the liquidation process. If the estate was insolvent, I would have imagined that they should have sold the property, settled the debts, and whatever was left should have gone to the mother's estate. So unfortunately, I wish I had a crystal ball to give you all the answers of how to solve for this right now. But I think once again, there's probably different factors involved that we will have to consider.
Sharon, thank you so much. Really appreciate it. The Senior Legal Advisor at Momentum with you on personal finance this evening.